Just like for tenants, California law gives landlords a bevy of rights, one of the most important of which is the right to evict a tenant for lease violation. In this, we're going to attempt to give you the general guidelines outlining the eviction process. Now, California is traditionally known as a tenant-friendly state. And with COVID, it's become even more so that way. That's why it's important for landlords to understand how the eviction process works and to make sure and seek the advice and guidance of an experienced eviction attorney to help them through the process. When you speak to your eviction attorney, there's some key things they're going to want to know. 1, the city in which the property is located. 2, they'll also want to know what type of property the tenants live in. Is it a single-family residence, a condo, a large apartment building, or what? Also, they'll need to know the specific lease violation. Is it for non-payment of rent, or was there some other sort of problem? Is the property subject to rent control? Does there need to be a just cause reason for the notice to vacate? And finally, is there any local ordinance in place that supersedes any sort of the county or state legislation? If your attorney determines that you're good to go forward with the eviction, here's what you can expect in the process. Step 1, post and deliver proper notice. So you need to actually post the notice on the property, and we also follow up by mailing certified mail the same notification. And this needs to be proper notice to be effective. So to be effective, you need A, it must be relative to the violation committed. So pay or quit for someone behind in their rent, or a cure or quit for some other sort of violation. B, it must inform them of the specific violation and give them the proper time frame to make good on it. So this can get real complicated, or I should say real specific. So is it a 3-day, a 10-day, a 15-day, a 30-day notice? And are those business days or actual calendar days? And the law keeps changing on these things. It's another reason why we strongly recommend you're in good communication with your eviction attorney during this process. And C, the information must be listed correctly. I mean exactly correctly. As an example, if someone's behind in the rent, it would include the tenant's names, the property address for which the rent's paid, the date when you made the rent demand to the tenant, name, address, and contact information where rent is payable, the amount of overdue rent, and please do not include late fees, that'll bite you. Also a certificate of service indicating how the notice was served to the tenant, and of course, a signature. So if by now your tenant hasn't made good on the violation, you move to step 2, which is file and serve the complaint. Now, you file in the appropriate superior court, and this is something called an unlawful detainer. And then that must be served to your tenant. And there are professional companies, there's a very specific way this needs to be done, and there are professionals who do this, and this is who you should use. And I'm sure your eviction attorney will help set this up for you. And your tenant will then have a specific period of time to either respond to the complaint or get out. So if your tenant responds by the deadline, you move to step 3, which is the court hearing and judgment. The eviction hearing will be set by the court, and you'll need to show up or have your property manager show up and meet your attorney there. And when you meet your attorney, you should be prepared with the following: a copy of the lease agreement, a copy of the eviction notice, the complaint, and any supporting evidence or documentation you may have. Let's face it, the courthouse hallway is where most of the negotiations happen. So that's why you or your property manager and your attorney will want to be there, and you can work this out, get the judge to okay it, and you move on to step 4, the writ of execution. And we call this the lockout date. Now, when it gets down to the lockout date, if the tenant is not out of there as agreed, you show up with a locksmith and you meet the sheriff at that day. There'll be posted notice. There's a whole legal process to that. And you open the door. If the locks have been changed, you have the locksmith open the door. The sheriff actually goes in. If your tenant's still there, they are physically removed. And then the locks are changed, the property secured. If there's any personal property left inside the unit, there's a personal property eviction procedure that goes on, or a post and store. It's, I believe, a 21-day notice at this time, but there's a process for what you do with that. But from any point here on out, your tenant goes back to that property. They are now trespassing, and you no longer need to evict them. You call and they're trespassing, and you call the police for that, and you just keep your paperwork on hand. Bottom line, owning rental property in California can be a great investment. It does, however, come with the risk of an occasional eviction. Process is very specific, can be complicated, can be certainly frustrating, and is absolutely something you should never attempt without the guidance and advice of a good eviction attorney. That also being said, it's never been more important than it is today to make sure you properly screen your tenants before renting to them. That can eliminate a good majority of these problems. And because it's bottom line, it takes more work than ever to get a non-performing tenant out of a property. But please, don't be afraid to be a landlord. And if you have any more questions about being a landlord and deciding how that all works, please feel free to reach out to the Mike Dunfee Group. We do property management, and we help people buy rental properties, and we would love to talk to you. Hope you found this interesting and useful. If so, please share and like, and we'll see you next time.